Welcome, everyone. I'm
Yay.
Gloria Palmer, the Executive Director of Green Mountain Academy for Lifelong Learning, and tonight's presenter is Vincent Bonaventre. He joined the Albany Law School faculty in 1990, where he is the Justice Robert H. Jackson Distinguished Professor of Law. He teaches, comments, and advises on courts, judges, and various areas of public law. He is the author of New York Court Watcher, a blog devoted to research and commentary on the U.S. Supreme Court and the New York Court of Appeals. He is also the founder and editor of State Constitutional Commentary, an annual publication of the Albany Law Review devoted to the American state constitutional law. And he's the founder and director of the Center for Judicial Process. We're very happy to have you with us again, Vincent. Thank you for being our guest.
Oh, thank you. It's just always so wonderful to be here. I wish I could actually be with you in person. I love to make my trips to Vermont to see you. And then also during the lecture, to look into your faces and see who's rolling their eyes because I'm saying something really stupid, or looking at me with daggers because you just hate what I'm saying. But it's always great to be with you because as an audience, you're just so attentive and smart. The questions are great. It's not always like that. It's not always, even with groups you would think would be brighter and on top of things. Most of them just don't compare to you guys. So it's always a thrill to be with you. So thank you so much for coming. Let me get this PowerPoint up. So here we are. I mean, a big change at the court with Ruth Bader Ginsburg passing away and her being replaced with Amy Coney Barrett at breakneck speed. And it's a big shift because as liberal, and I'm talking about socially and politically liberal, as Ruth Bader Ginsburg was, that's about as socially and politically conservative as Amy Coney Barrett appears to be. So we're going to be looking at the shift and particularly what that might mean for the important issues that come before the United States Supreme Court. So we're going to be looking at the lineups, what the lineups were before, what they are now. And because of the change, it's really important what has happened. And it's very consequential. We're going to be looking at the last term. The last term was really a blockbuster term, but it was also a term that was very revealing about the court. It certainly showed, as other terms have showed, how politically and socially liberal Ginsburg has been, but also how Chief Justice Roberts has become the swing vote on the court. It really has become his court. In previous terms, especially when Justice Anthony Kennedy was on the court, it was often said that it was his court, and that's because he was the swing vote. He's the one that made the difference. But for the last couple of years, it really has been the Chief Justice. So it's important to keep a watch on him. The conservative Barrett, and again, I am not talking in terms of judicial restraint or strict construction or originalism or any of these other felicitous concepts, which when you actually look at how these justices are voting, you can connect the dots and see what's really there, as opposed to their self-proclaimed originalism or strict constructionism or something else. Well, we don't have much in terms of her at the United States Supreme Court yet. We do have one, at least, very important decision at the court. But what we do have is we have her record on the Seventh Circuit Court of Appeals. And we will take a look at that, especially at her dissents. We're talking about opinions where she went out on a limb to disagree with her colleagues. She went public telling the world that her colleagues were wrong. They were so wrong on a matter that's so important, she had to go public with her disagreement. We're going to take a look at what she thought was so important that she had to dissent against her colleagues. Then we're going to look at the impact. And particularly, we will look at some of the cases that are coming before the court this term, some of the other issues that will be coming before the court either this term or in the near future. We'll look at that. And then finally, some few concluding observations. All right, the lineups. Well, here's the court, right? Here's the court. You got the, Gloria, can you see my pointer?
Yes, I can.
Okay. So you've got the chief, of course, John Roberts, Clarence Thomas, who's the senior justice on the court, Ruth Bader Ginsburg, of course, Stephen Breyer, Samuel Alito, Sonia Sotomayor, Elena Kagan, Neil Gorsuch, and Brett Kavanaugh. A little bit more about them. Here they are. Ruth Bader Ginsburg, who, of course, just passed away at the age of 87 in September. She had been on the court for 27 years. Breyer, and now there is some talk about the liberals, Democrats and the liberals, urging him to retire, just as they had urged Ginsburg to retire when Obama was president. Now it seems as though we have a bunch of Democrats who are really encouraging Breyer to retire, at least retire at the beginning of Biden's term, President-elect Biden's term, so Biden can replace him with another liberal. We have Clarence Thomas. He's only 72 years of age, and he's been on the court already for 29 years. 29 years. And of course, he has been speaking. Why has he been speaking? Because the court has been hearing oral arguments by audio. There's no oral arguments at the court, but by audio. And the Chief Justice, after he asks some questions, he gives each one of the justices several minutes to ask their questions, and he will call upon, next in line, Clarence Thomas. What are your questions? And Justice Thomas has been asking questions. And of course, he's been very, very conservative. And again, we're talking about social, political, ideologically conservative, right? Samuel Alito, 70. He's been on the court for 14 years already. And again, another real conservative member of the court. We have the chief, right? He's 65. He'll be 66 very, very soon. And he's been on the court, again, just like Samuel Alito, for 15 years. Conservative, but a moderate conservative. Sonia Sotomayor, 66 years. She's been on the court for 11 years, right? An Obama appointee, very liberal member of the court. Elena Kagan, also an Obama appointee, 60 years of age. She's been on the court for 10 years, and she's definitely a liberal Democrat. Maybe not in the same camp as Sotomayor and Ginsburg was, but certainly liberal. Neil Gorsuch, 53 years old. Now we get into those justices who were very young compared to justices generally on the Supreme Court, which means that we can expect them to be there for a long time. Neil Gorsuch, 53, only been on the court for 3 years. He's the first Trump appointee, very conservative. Brett Kavanaugh, 55 years, right? 2 years on the court, the second Trump appointee, conservative, perhaps not nearly as conservative as Gorsuch or Alito or Thomas, but nevertheless conservative. And of course, when we speak in terms of conservative or liberal, those are not proxies for good or bad, wise or foolish, correct, incorrect. I have my views, you have your views, but that's not the point of this at all. It's just to lay out what the facts actually are based upon their voting. And Gorsuch is very conservative, and Brett Kavanaugh is pretty conservative, but not nearly so much. So last term, all the eyes were on the Chief Justice and on Ruth Bader Ginsburg. They were on the Chief Justice because it has become his court. He was the one that was in the majority in virtually every single case. And many times he was in the majority because he's the one that cast the fifth vote to make the side that won the majority. And Ruth Bader Ginsburg, because she had been in such failing health that everybody was wondering just how long could she hold on. Here was the ideological lineup of the last term. You had the four liberals and, of course, Ruth Bader Ginsburg. You had the four conservatives, right? From most conservative to somewhat less conservative. And the swing vote, right? The center of the court, you had the Chief Justice. So 4 liberals, 4 conservatives, and you had a moderately conservative Chief Justice who really was a centrist. Let's take a look at one of the cases from the end of last term. It was a 5-4 decision. And look, you've got the Chief Justice, and he's with the 4 liberals, including with, of course, Ruth Bader Ginsburg. The other Republicans on the court, the other conservatives, they're now in dissent. 5-4 decision. And in this decision, the Supreme Court, by just the barest majority because of the Chief Justice, deferred to the state of California and the state of California's pandemic restrictions against objections by churches, including the South Bay United Pentecostal Church, saying that these restrictions were violations of free exercise of religion because they could not allow all their believers into the church. And there were hygiene restrictions such as masks and social distancing. The church complained about those. And the court, in a per curiam opinion, meaning the court didn't even bother hearing oral arguments, and nobody on the court actually even signed the opinion. The court, in other words, did this rather summarily, except the Chief Justice did feel it incumbent upon himself to explain why the dissenters were wrong, because the dissenters were saying, why are you treating churches like this? And so the Chief Justice explained to the dissenters that at churches, as opposed to at bars or at casinos or at Walmart, people gather together for a lengthy period of time, and they often are very, very close together, and they're praying out loud and they're singing out loud. And those seem to be ways to really spread the pandemic. So he said churches are very different than other activities which are treating differently, and that difference justified the restrictions on churches. That was in May. We still had Ruth Bader Ginsburg on the court. Shortly thereafter, Ruth Bader Ginsburg passed away. Trump's third nominee, Amy Coney Barrett, she was confirmed October 27. Less than a month later, an analogous case to the one coming out of California, this one coming out of New York City, the Roman Catholic Diocese of Brooklyn, challenged similar pandemic restrictions. Now with Ginsburg gone, Amy Coney Barrett replacing her. Now it's 5 conservatives on the court. The 4 who were in dissent, they're now joined by Amy Coney Barrett. And they are now saying that these pandemic restrictions are almost certainly unconstitutional, and therefore they are to be stopped. They may not be put into effect. And you will see that here, these justices who had been in the majority in the California case, they're now in dissent. They're now in dissent because they are missing Ruth Bader Ginsburg, and instead of her, there's Amy Coney Barrett joining the conservatives. That gives us an idea of how this court is going to behave with Ruth Bader Ginsburg gone and Amy Coney Barrett taking her place. Again, here's the ideological lineup. You're going to see this particular picture quite a few times because I want this etched into your head so you understand how consequential it is that Ruth Bader Ginsburg is gone. I'm not talking about that you have to like Ruth Bader Ginsburg, or you have to like the way she votes. I'm just talking about it really makes a big difference that she's gone. It made a big difference that she was on the court. And it made a big difference that the Chief Justice has moderated and he's become the swing vote. And again, here's with Barrett having replaced Ruth Bader Ginsburg. Now we only have 3 liberals on the court instead of 4. And now we have 5 pretty solid conservatives on the court. You have another conservative, but his role may well be diminished because the stauncher conservatives on the court, they just don't need him for a majority anymore. So even if John Roberts votes with the liberals, as he did in the New York City pandemic case, it won't make any difference because there are still 5 staunch conservative votes on the court, which will make up the majority without him. Now, one thing that's interesting is that if Biden was the one replacing Ruth Bader Ginsburg, it really wouldn't have made any difference. It would not have changed the court. It would not have changed the court. He'd just be replacing one liberal, Ginsburg, with another liberal who he surely would have nominated. And you would still have had 4 liberals, 4 conservatives, and the liberals would have needed John Roberts' vote. So that wouldn't have changed much.
Okay, Vincent, I have a question.
Yeah, go ahead. Yeah.
Okay, so there's Ellen asked, don't you agree that the majority of the New York case was objecting to the specific restrictions that differed from California and had ceased to be operative at the time of the decision? The majority opinion should allow more narrowly tailored state restrictions.
Well, what a good question. See, that's why I love being here. There was a procedural obstacle to the court even hearing that case because the New York restrictions had elapsed. Nevertheless, what the conservative majority said, and they're not entirely wrong at all. What they said was that if they just decide to say that this case is moot, they don't have to hear this case because those restrictions don't apply anymore, then what could happen is a state such as New York or California or any other case or any other state, once their case got to the United States Supreme Court, they just amend their restrictions. Or they would just eliminate their restrictions. And the Supreme Court would never be able to hear the case or a case similar to that. And so you had the conservatives on the court saying, this is the kind of situation that is very, very likely to recur. And so we ought to consider this case, even though technically it is moot. Look, the liberals did the same thing in the abortion cases. Roe versus Wade, for example, technically was moot by the time it got to the United States Supreme Court, because Roe, who wanted an abortion, had already given birth. And therefore, the question about the abortion really was moot. But the liberals said this is the kind of question which will recur, and that's an exception to the procedural rule of mootness. Mootness meaning that you really don't have a controversy anymore because something has happened to settle the controversy. Well, the conservatives in the New York City case said, nah, this is going to happen again and again and again. And if we don't address this, we may never be able to address this kind of situation, and there won't be a law out there, there won't be case law out there to govern whether or not states should be allowed to do what they're doing. All right? I guess that's yes. Okay. So the liberal Ginsburg, a swing vote Roberts. Let's take a look at last term. It really was a blockbuster term. And again, here it is. I told you you're going to be seeing this quite a bit. This is the court for the last few terms. Not anymore, but this is what it was the last few terms. Again, Chief Justice John Roberts. I thought that was a great photo because, you know, Trump now hates Chief Justice Roberts. And Chief Justice Roberts, I'm not too sure, has too much respect for the president. And Chief Justice Roberts has made it clear that he and his court will be independent of the president and of any pressure from the president or the president's inner circle. And again, he's 66, 15 years on the court, appointed by Bush 43, and he is a conservative Republican. Let's not fool ourselves into thinking that he's a liberal. He's not I mean, if you're a real right-winger, you will think he's liberal, but I mean, in the abstract, I mean, to be neutral about it, he is a conservative Republican, but he's a moderately conservative Republican. And Ruth Bader Ginsburg, isn't that a great shot? Isn't that a great shot? So that's 1993. She's just nominated by Clinton, and he's taking the walk to announce his nomination. And there she is, this last term, right? And she passes away in September, having been on the court for 27 years and very, very liberal. Here's another way of looking at it. Last year, when we look at those hot button questions, what do we mean by hot button questions? Well, we're talking about questions where there's very, very clear divide between social political conservatives and social political liberals. So, for example, separation of church and state, gay rights, racial issues, gun rights, abortion, affirmative action, voting rights, immigration, death penalty, environmental regulations, worker rights, consumer rights, campaign finance, and anything having to do with Trump and anything having to do with Obama, right? So those kinds of questions, that's what we're talking about. There happened to be 27 of them last year, so almost half their docket. As I've said before at my lectures with you, you know, this is not exactly an overworked court. They decide about 60 cases a year. So 27 of them last year were really hot button. I mean, there were other cases where you would have a liberal side and a conservative side, but I'm talking about those which are really controversial ideologically. Now, among those cases, you could see Ginsburg, 96% of the time, she voted liberal. Only beaten by Sotomayor was 100. Sotomayor absolutely never saw any merit in the other side. Ginsburg virtually never did. I think there was one case. I'm pretty sure one case, and I know the case it was. 52%, the court itself was 52% liberal. So we're talking about 50-50. On these questions, these hot button questions, the court was just about 50-50. Now you say, why? Well, you look at the liberals, right? The four liberals, Sotomayor, Ginsburg, Kagan, Breyer, four liberals. All they need is one more vote. They were getting Roberts' vote almost half the time. Sometimes they would even get Gorsuch's vote, right? And actually, in a couple of important cases, they did get Gorsuch's vote. Very, very interesting. Of course, on the other end of the spectrum, you have Alito and Thomas, never see any merit in the other side. Gorsuch, not too frequently. Kavanaugh, a little more frequently. And Roberts, somewhat close to 50-50. Now, this wasn't an aberration. Look at the previous year, right? The previous year, again, the court was about 50-50. Ginsburg and Sotomayor, just about the same. Breyer and Kagan. And Roberts, right? Roberts was more than 40%. liberal on the court. So that's what's been happening. And here, this is just turning it around about conservative.
Okay, can I just
interrupt? Go ahead. Sure. Go ahead.
We have another question here from Karen. Kavanaugh and Roberts sided with the liberals on a landmark case involving water pollution in Hawaii brought by Earth Justice.
Oh, yeah. Isn't that great? Yeah.
How do you see the court on environmental issues?
That's so interesting. And actually, I was going to talk about that case, and we'll still talk about it. But environmental issues and Indian issues like Indian law, the rights of the tribes. Gorsuch seems to have a liberal streak in him. Kavanaugh seems to have a liberal streak in him. So we may see these. Now, when we talk about these justices being liberal or conservative, unless you're talking about, Sotomayor and Ginsburg at one end, or you're talking about Thomas and Alito at the other end, they're not 100%. Socially and politically conservative or socially and politically liberal. So there will be some issues on which the liberals will be able to get Kavanaugh or even Gorsuch. And by the way, and the conservatives will be able to get Kagan or a Breyer. So that does happen. So in none of these cases, well, I shouldn't say in none of these cases. In the case of Thomas, Alito, Sotomayor, and Ginsburg, it was almost absolute. But with regard to the rest of the court, it's not an absolute ideology that's governing them or informing their votes. So yeah, we always have to look out for those. And I'll tell you another reason why that's such a great question is because when you would argue before the United States Supreme Court or any of the state Supreme Courts, if you, for example, figure, well, I've got all the liberal votes, but I need one conservative vote. Well, you look at those times in which a Gorsuch or a Kavanaugh voted with the liberals, and you find out what is it that moved them? What is it that moved them? So the very, very landmark LGBTQ case this past year, the advocates figured out how to get Gorsuch's vote, even though in previous cases dealing with gay rights, same-sex marriage, I mean, he was just astonishingly homophobic in those cases. They actually got Gorsuch's vote in favor of LGBTQ rights because they zeroed in on it. And we'll talk about that. All right?
Then could we just
Absolutely.
Stay on the environmental issue because we have a question from Bill. He says, I expect the composition of the new court gives hope to a movement for the dismantling of the regulatory state, environmental and conservation, financial, for example, Wall Street, consumer protections, food safety and food standards, workers' rights and safety, transportation, by securing rulings which, one, void previous rulings in which Congress delegated authority to agencies of the executive branch to issue regulations. The goal of those special interests is to push for a ruling that only Congress itself can approve rules and regulations on clean air, securities, filings, health, and safety. And there is a second part. I don't know if you want to address that first or.
Sure, let me address that. We have not seen in this country since the pre-New Deal such an antipathy among certain justices against regulation by independent regulatory agencies. Now, in the pre-New Deal, with all the social welfare legislation, whether it was coming from the federal government or whether it was coming from the states, dealing with, for example, minimum wages, maximum hour, child labor, worker rights, consumer rights, Social Security, labor rights, the Supreme Court repeatedly would invalidate those regulations on the ground that those regulations had to be enacted by Congress. and that Congress could not delegate authority to these independent agencies. Well, of course, the reason for independent agencies was to immunize them from the current, the ephemeral political emotions, right? To make them independent of political pressure. Of course, the other side of that is that if the independent agencies are immune from political pressure, that really diminishes direct democracy. That is, it diminishes the extent to which the people, through their representatives, can determine what the law is. So if independent agencies are promulgating these regulations, it's not the people's own representatives. So it's not clearly one way or the other. We certainly don't want in a democracy to have individuals who don't have to be accountable to the people at all to be able to be making laws. That's the argument against independent agencies. On the other hand, when we have very, very important matters, such as the environment, such as worker safety, such as Social Security, on and on and on and on, we don't necessarily want that those kinds of protections to be held hostage to the politics of the day. So, I mean, there's merit both ways. But the court today, when you talk about Kavanaugh, even Gorsuch, Thomas, Alito, and certainly Amy Coney Barrett, they are generally hostile to regulations. They are generally hostile to regulations. And in fact, this past year, there was a case involving Trump's firing of the director of the Consumer Protective Agency. The Democrats were saying, no, that's supposed to be an independent agency. The Supreme Court majority, a bare majority, held that Trump did have the authority to remove the director of that agency because that agency should not be as independent as it had been, because the agency was really promulgating some very substantive environmental regulations. So that may be a precursor of what we're going to see, especially now that we have Amy Coney Barrett on the court. Great. What's next?
So the second part here was rulings that prohibit states from promulgating their own rules in this area. For example, California's air quality standards by declaring that such actions are only permitted by Congress pursuant to the Constitution's Interstate Commerce Clause. Your thoughts?
Right. Okay, look, this is one of those areas of the law where you have to revert back to, okay, the world's a fake. So what you have is you have those justices on the court who are always talking about states' rights, who are always talking about we're conservatives and we believe that the laws should be made at the local level, and the local level is the most responsive to the people. They are exactly the ones in these cases, and we call them preemption cases. Are the states preempted from legislating in this area? Are the states and local governments preempted from regulating this particular area? Oftentimes what happens, if we're talking about restrictions on business or the accountability of business, it's those justices who claim to be in favor of local governments and states' rights. Those are the ones who suddenly vote against the states and against the local governments. Again, you have to look beyond their self-proclaimed judicial philosophy, and you have to look at the particular interests involved. So if we're talking about business interests, and you have the business community is seriously objecting to these regulations, you will find that the conservative justices who are typically in favor of states' rights, they will vote against the states and the localities and in favor of business. To be fair, The liberals, who usually don't give too much of a darn about state and local governments, except when they're promulgating things that are liberal, they're all of a sudden will be talking about states' rights and local governments' latitude in promulgating these regulations. So yeah, you have to look at what the issue actually is. Don't pay too much attention about judicial philosophy. Look at what the issue is and what interests are going to be affected. That will be a much more accurate way of figuring out how these justices are voting and why they are voting this way. Very good, very good. My students ask that kind of question all the time because they're bewildered, because they want to believe that these justices have this strict philosophy of how they decide cases and they're just sticking with it. Well, that's not what happens. You know, nobody goes to war over strict construction. Nobody goes to war over originalism. Nobody goes to war over judicial restraint, but they go to war over, you know, gay rights, church and state, race, business regulations, Obamacare. You know, they go to war over those things. And there's the previous year, the same thing. All right, look at what happened last term. And in green are the ones where the libs with Ginsburg won. And these, and I could have had more, but these are the ones that I wanted to speak about, you know, Ginsburg together with Roberts. But presidential immunity, right, the two cases, Trump, church and state, we had a bunch of them, abortion restrictions, LGBTQ rights, immigration, Indian law, gun rights, the environment, right to a jury trial. We had voting rights, election law, consumer protection, the insanity defense, which was diluted, death penalty. So we had so many of these hot button issues in this blockbuster term. Trump versus Vance, Vance being the district attorney in Manhattan County in New York. The vote was 7-2 for the general proposition that the president is not immune from criminal subpoenas coming out of state courts. The president is not above the law. However, you have to look a little deeper into the case, and the vote was actually 5-4 for the proposition that the president had to answer state criminal subpoenas just like anybody else did. And because it was a subpoena coming out of the state, the court didn't have to scrutinize the subpoena any more than it would any other subpoena. The two dissenters in the case, as well as the two concurring justices, they agreed with the result in the case, but not the rule of law. These four said that the president should not have to respond to a state subpoena. These two said should not have to respond at all. And these two said that should only have to respond if these subpoenas were very, very, very strictly scrutinized, much more so than a federal subpoena. So it was a 5-4 vote. Don't forget, Ginsburg is now gone. I'm pretty darn sure the vote would be 5-4 the other way now. And of course, with regard to congressional subpoenas, 7-2, speaking through Roberts again, the president's not above the law, but come on, Congress, you're engaged in a fishing expedition. You got to more narrowly tailor your subpoena. And Alito and Thomas, they didn't want the president to have to respond at all unless Congress can show that it was for a very, very specific piece of legislation. And we already spoke about this, the California pandemic restrictions, 5-4, Roberts joining Ginsburg and the libs. But we had other religious liberty cases, Little Sisters of the Poor. They didn't want to pay for contraceptive insurance. Not only that, they didn't even want to have to tell the government or the insurance company that they didn't want to pay for it. And the Little Sisters of the Poor won 7-2. The two liberals who joined the conservatives on the court said, well, I think we should look a little more closely at regulations which allow just about anybody to be exempt from a generally applicable law. But 7-2 for the Little Sisters. I mean, come on, how could you root against the Little Sisters? Our Lady of Guadalupe, this is a huge one. This is a huge one. It's 7-2. I don't know how there were 7 votes. I certainly would have imagined at least 5, but 7. And in this case, just like the Catholic Church can restrict the priesthood to men, and that's called the ministerial exception. The court doesn't want to get too involved in the governance of a church. And so anti-discrimination laws do not apply to the Catholic Church in saying we're only going to have men as priests. Well, in this case, the court extended that exception from anti-discrimination laws, extended it to teachers in parochial schools, in this case, teachers in Catholic schools. The 7-2 majority said the teachers in Catholic schools are basically the same thing as priests in terms of the ministerial exception. And so the Catholic school could fire somebody for age, and they could fire somebody else for disability. And even though that normally would be prohibited by the anti-discrimination laws, the Catholic Church, the Catholic school, and other religious schools are immune from these anti-discrimination laws with regard to teachers in their schools. Espinoza, in this case, 5-4. Montana scholarships to any student who did very, very well, but Montana, because it has one of these laws that prohibits even indirect aid to a religious organization, Montana would not allow a student who was going to a religiously affiliated school to be eligible for the scholarship. Well, the court 5-4, Roberts now joining the conservatives, 5-4, saying the way Montana was doing it was discrimination against religion, and that violates the First Amendment. The 4 in the dissent, speaking through Ginsburg, were saying, hey, this is a violation of non-establishment. This is a violation of the separation of church and state, because by giving scholarships to students who are going to parochial schools, we're necessarily supporting the religiously affiliated schools and the religion that they teach. 5-4. This is a conflict between free exercise of religion on the one hand and non-establishment on the other. When you get that kind of a conflict, free exercise, people should not be penalized because the practice of their religion. Non-establishment, government ought not to be supporting religion. When you get that clash, typically you have the conservatives are in favor of free exercise, accommodating religious practice, and you have the liberals who want that separation of church and state. That's what you had here. The abortion case, 5-4, and it's 5-4 only because Roberts joined the liberals. So you had Louisiana's abortion law, which was basically the same thing as the Texas law, which was invalidated a couple of years earlier. You had Roberts, who actually was in dissent in the Texas law case in 2016. This time he joins the liberals in throwing it out. In that 2016 case, who made up the majority? The 4 liberals and, yep, Anthony Kennedy, the swing vote. Anthony Kennedy's now gone. Even though Roberts was in dissent in 2016, he now writes an opinion and he says, just because there's been a change in the composition of the court does not mean we ought simply to be throwing out precedents. And so he joined with the liberals on the court strictly on the basis of stare decisis, strictly on the basis of precedent, even though he happened to disagree with that precedent. Actually, in the year before, he voted with the liberals to halt the enforcement of that law until the court could hear the entire case, which it just did. Here's the sex discrimination case somebody was interested in. All right, 6-3. You have the Civil Rights Law of 1964. Think back. Those of you like me who can think back to 1964, right? Think back to 1964 and what the climate in the country was, what the climate and the attitude was of Congress and the Senate, right? And of people generally. The Civil Rights Law. I mean, it was tough enough to get a law passed that would prohibit racial discrimination. But at the last minute, and it was supposed to be a poison pill, and a poison pill, what was added to the Civil Rights Law was prohibiting discrimination on the basis of sex. Well, the Civil Rights Law passed, including prohibition against discrimination on the basis of sex. Well, in this case that came before the Supreme Court last year, you had somebody fired because they were involved in a same-sex marriage, and you had somebody else fired because that person was transgender. And the question was whether the prohibition against sex discrimination in the Civil Rights Law of 1964 covered LGBTQ rights. In other words, did it also prohibit discrimination on the basis of sexual orientation? The court ruled 6-3 that it did also prohibit discrimination on the basis of sexual orientation. And this is the reasoning of the court. Now you can see you got Roberts, he's with Ginsburg and the other liberals, and then you have Gorsuch. Now, how is Gorsuch going to get around his self-avowed originalism? Not only that, we've had two previous cases in which Gorsuch wrote, in one same-sex marriage case, he said that the Supreme Court had held that same-sex couples were allowed to be married. We did not say that they were entitled to the benefits of married couples. I mean, I don't know where he comes up with that one, but he lost. He was in dissent. The other case had to do with the baker who did not want to bake a cake for a same-sex wedding. And Gorsuch wrote in a separate opinion that the baker was not discriminating against same-sex couples because the baker would not bake a same-sex cake even for an opposite-sex couple. So with those two opinions of his in mind, you couldn't have too much hope for him voting in favor of anti-discrimination for LGBTQ in this case. Nevertheless, whoever was advocating this case knew how to get to Gorsuch and convinced Gorsuch that the original meaning of sex discrimination in 1964 included sexual orientation discrimination. So instead of simply saying that the logic of it, that is, if a man's married to a woman, he keeps his job. If it's a woman married to a woman, she gets fired. The only difference is sex. Instead of just leaving it with that, he went on about how in 1964, the public meaning of sex discrimination included discrimination on the basis of sexual orientation. Well, Alito wrote a very, very lengthy, I think it was 107 pages, showing how absolutely absurd that argument was by Gorsuch. One of the interesting things is that none of the liberals objected to this originalism of Gorsuch. Instead of just saying, look, we could reach the same result just on the basis of pure logic or on the basis of the overriding principle that when you have something that even involves sexual differences, that with regard to employment, that difference is invidious. It's irrelevant. The different treatment ought not to be allowed. But Gorsuch went on with this originalism thing. The liberals did not object to that, and I'm sure Gorsuch is going to throw it in the liberals' faces in the future. But in any event, another interesting thing is that Roberts, who in the past had voted against LGBTQ rights, he's been pretty consistent in voting in favor of LGBTQ rights the last few years. Another thing about Gorsuch, now having been on the side of LGBTQ persons, the question is, what is he going to do in the cases that are coming before the Supreme Court now, which have, on the one hand, religious rights against LGBTQ rights? What's going to happen there? Because there's going to be a clash between religious freedom and the way Gorsuch has been viewing religious freedom on the one hand, and LGBTQ rights on the other hand, where, other than in this case, it doesn't seem as though Gorsuch has much sympathy. On the other hand, you have the dissenters. I mean, not surprising. Thomas has voted against LGBTQ rights. I don't care what the context, what the issue. Like his buddy Antonin, the late great Antonin Scalia, he never voted in favor of LGBTQ rights, no matter what the case. Alito, on the other hand, I think had the much stronger argument with regard to originalism. And he was saying it's absolutely, in 107 pages, he said it's absolutely ridiculous to think back in 1964, when Congress prohibited sex discrimination, they were thinking about same-sex couples, or they were thinking about transgenders, or they were thinking about sexual orientation. So 6-3, we will see what happens in subsequent LGBTQ cases, again, when it's LGBTQ rights against religious rights. Department of Homeland Security, this is a great, one of my, I have to admit, this is one of my favorites. It's 5-4. You see Roberts joining the libs, 5-4, the libs plus Roberts against the conservatives on the court. Do I even need to tell you what happened? This is about deferred action for childhood arrivals. You know, here's the liberals, you know, DACA is going to be upheld. And sure enough, that's what happened. But why did it happen? And why did Roberts join with the liberals to say that Trump could not repeal DACA? Well, what Roberts did say was that we are not saying that a presidential administration could not repeal DACA. They could, but don't come into my court and lie as to why you're doing it. And so the regulation, which was to repeal DACA, was arbitrary and capricious because you came into my court with post-litigation rationalization. And what you are saying does not support the record as to why you actually want to get rid of DACA. We know why they want to get rid of DACA, for political reasons. So he says, don't come into my court and lie, and because you're lying, you lose. The four in dissent were saying that regardless of the reasons that the Trump administration had previously, because DACA was illegal to begin with, the court ought to allow the Trump administration to repeal it. But institutional integrity, Roberts was pretty darn angry about the Trump administration coming into his court and lying. He said the exact same thing last year, if you remember, when the Trump administration wanted to put the citizenship question on the census. They came to his court and they said, well, look, we're allowed to do this. There's nothing unconstitutional about having a citizenship question. There have been citizenship questions on census forms on various times in the past, so we have the power to do so. Roberts, once again, with the liberals, said, I'm not saying you can't have a citizenship question on the census form, but don't come into my court and make up reasons why you're doing it. We know why you're doing it, because you want to reduce the number of those non-citizens who will fill out the census form. We know that from evidence in the record. So don't come up to us and say, you're coming to our court, and the reason why you want the citizenship question is to protect voting rights. I mean, you could, we know that's not the case. And Roberts was saying, that's a darn lie. Of course, he said it in his own nicely judicious way. He said, your reasons you're coming before the court are they are contrived, and they don't match the record in this case at all. So you can't do it. And the foreign dissent were saying, look, it's perfectly within the powers of the president to include a citizenship question. Again, Roberts said that is true, but don't come into my court and lie about why you want to do it. 2 cases in a row. Here's an important one. Another one having to do with immigration, like the DACA case. This had to do with a non-citizen who was going to be deported, but he was claiming that he would be subject to torture if he was sent back to his native country. And so he said, under the International Torture Convention, the Treaty Against Torture, right, the Convention Against Torture, he said, I'm entitled to a hearing. And the court 7-2, of course, Roberts now joining with Ginsburg and the liberals, and Kavanaugh as well now, said, and Gorsuch, saying that, yes, this immigrant, this non-citizen is entitled to a hearing to determine the bona fides of his claim that he will be tortured if he goes back. The 2, Thomas and Alito, is saying that the judiciary has absolutely no business reviewing immigration decisions. But anyway, there's 7 votes against them. Important case. Here's a fascinating, oh boy, is this a fascinating case. McGirt versus Oklahoma, 5-4. You got the 4 liberals, and you've got Gorsuch joining the 4 liberals. Did you have a question? Oh, I'm sorry. I thought I heard somebody. You have Gorsuch joining the 4 liberals, but actually it might be Gorsuch leading the pack in this case. And you had Thomas writing for the conservatives. This case involved an 1832 treaty with the Creek Nation. And under that treaty, the Creek Nation was given a huge swath of Oklahoma. So most of eastern Oklahoma was part of the Creek Nation's territory. All right. And in accordance with the treaty, Oklahoma would have no power to prosecute crimes committed by Indians in the Indian Territory. Well, Oklahoma's been doing that anyway. But finally, McGirt objected to it. The case gained to the Supreme Court, and Gorsuch, who has a record, even as an appellate judge, of actually supporting Indians and being strict about enforcing Indian law, he joined with the liberals to say, sorry, Oklahoma, you have no jurisdiction over crimes committed in Indian territory. Now, what Roberts said was, this is really going to rock stability because Oklahoma has been prosecuting cases in Indian territory. And in fact, in states all around the country, states have been prosecuting crimes committed in Indian territory. So it's really going to make things unstable, right? But Gorsuch and the liberals said, that's too bad. We are going to enforce this treaty, and we don't care if it's been violated for over 100 years. We are going to enforce it now. The real question is, if that treaty is actually going to be enforced, what does that mean for the power of the state of Oklahoma to do just about anything within that Indian territory? Well, we don't know. Stay tuned. The interesting thing is the year before, there was also a 5-4 case. It was the liberals. You had Sotomayor. And look who was joining the liberals. Gorsuch again, on the side of the Indians. In this case, it had to do with the Crow tribe's right to hunt. And Wyoming was saying, hey, their right to hunt was in unoccupied lands of the United States. But once we became a state, it wasn't an unoccupied land. And once that land became part of the Bighorn National Forest, it wasn't unoccupied land. Well, the four liberals with Gorsuch said, too bad, under that 1868 treaty, it was unoccupied at the time, and that's what we're sticking to. Fascinating. All right, here's a case, and here's a case related to one of the questions earlier. This case had to do with the New York City ordinance. Very, very strict with regard to gun possession. And someone who had a gun license in New York not being permitted to leave New York City with that gun which was licensed in New York City. Well, by the time the case got to the United States Supreme Court, New York City had amended its ordinance so that that gun restriction, that gun possession restriction, that restriction on carrying the weapon outside of New York City, that was deleted. So the case gets up to the Supreme Court, and the United States Supreme Court, the liberals, of course, but this time joined by Roberts and even Kavanaugh, said, okay, New York amended its law. The provision in its law, which you're objecting to, doesn't exist anymore. Case is moot. Case is moot. There's no controversy anymore. Well, you know what the three real conservatives on the court said. They said, wait a minute. What's going to happen now is every time you have a state or a locale that has gun restrictions that are very, very questionable, as soon as they get to the Supreme Court, they're going to delete that provision, and then we're never going to be able to hear it. And by doing what you are doing, majority, you are really demoting gun rights to second class, because instead of going out of our way, taking this case to laying down the law that states and localities are not allowed to do what New York City tried to do, you are calling this case moot, and therefore you're not giving guidance. You're not giving guidance. So this case is moot, 6-3. I don't think Amy Coney Barrett would have been with the majority in this case, but it, of course, would still be 5-4. Here's a case that one of you asked about. And this had to do with direct discharges of pollutants, direct discharges into navigable waters. And the question was, what happens when you have a business or a county or anyone else who is discharging into a waterway which then flows into a navigable waterway? Is that discharge into that minor waterway, is that covered by the Clean Water Act? Well, the majority of the court, 6-3, and now who we have is we have Kavanaugh joining Roberts and the liberals. Kavanaugh joining them, saying, look, as long as it's the functional equivalent, in other words, if the pollution is being discharged into a minor waterway, but that discharge is necessarily going to go into a navigable water, that's enough. That the Clean Water Act isn't just restricted to that pollution which is discharged by a pipe directly into the navigable waterway. So if it's discharged into some minor waterway, which necessarily is going to go into the navigable waterway, that's enough. You had Gorsuch, Thomas, and Alito, and they were taking a much more literalist view of the Clean Water Act. And of course, business interests. You had business interests, and you had, environmental concerns, right? Environmental concerns versus local government, but also necessarily by extension, environmental concerns versus big business. Okay, let's take a look at Ginsburg this past term. In every single church and state case, in every one, she voted against the church, right? Or the religious objector. Or stated otherwise, she always voted for separation of church and state. She always voted against government supporting religion. She always voted against government making special accommodations for religious practice, even against very important laws. In criminal cases, every single one, she voted for the right of the accused. And that included in every time there was a death penalty case, she always voted for the death penalty inmate. In all those cases in which the Chief Justice voted with the liberals, she was always with the Chief Justice. And voting alignment in every single hot button case but one. Every single one. The one case, I'm trying to think back to it, the one case had to do with whether or not, it was a really technical one, but it made a big difference for a gas pipeline and whether or not the gas pipeline was allowed to go underneath national forest land. And she voted with the conservatives to say that the gas pipeline should be allowed to go underneath the national forest land. And as you can imagine, everybody else voted exactly the way you would think they would vote. Okay, but let's make it clear one thing. Ginsburg was on the side of the majority in these hot button cases almost 60% of the time. But not all of the time. 40% of the time, she was in dissent. 40% of the time, she was in dissent. And then look at Roberts, 93% of the time. So I think there were two cases in which he was not with the majority. Another fascinating thing, the two most conservative members of the court, Alito and Thomas, they were only in the majority about half the time. The same thing for Sotomayor, only about half the time, But this is a really interesting 93% of the time in the majority for Roberts, and even Kavanaugh, 80% of the time. Just flip that around in the dissent. Robert virtually never in the dissent. Alito, Thomas, and Sotomayor in dissent about half the time. Look at this, Roberts with the liberals. The California pandemic restrictions. And remember, that was a 5-4 case. There was a majority only because Ginsburg was on the court. June medical services, the abortion restrictions in Texas. Abortion cannot be provided except by a health professional who has hospital privileges within 30 miles, which basically eliminated virtually all reproductive health facilities in the state of Louisiana, as was attempted in Texas. 5-4, those abortion restrictions were invalidated as undue burdens on the right to choose. Again, 5-4. Absolutely no doubt in my mind that that case would be decided differently if, decided differently if Amy Coney Barrett was on the court. The Regents case, this had to do with the DACA repeal. Ginsburg off the court, Amy Coney Barrett almost certainly going to be joining the conservatives. The subpoena case, the state subpoena case, remember it was only 5-4 that the president had to respond to state subpoenas, the same as any other citizen. That was only 5-4. Little doubt in my mind, Amy Coney Barrett would be joining the conservatives. That case would have flipped. The discharge of pollutants case, 6-3, maybe it would go to 5-4. The LGBTQ case might have gone to 5-4. But I also wonder, with Amy Coney Barrett in the court, whether or not Gorsuch actually would have joined with Roberts on the side of LGBTQ rights. I'm not convinced about that. So we'll see in the next several LGBTQ rights cases. Whether or not the New York City ordinance gun restrictions case was moot, I'm almost positive she would have voted the other way. Department of Commerce case, the citizenship question, Ginsburg gone, Amy Coney Barrett. I'm pretty darn sure she would have allowed the Trump administration to put the citizenship question back on the census form. The Louisiana abortion restriction is the same. I'm sure she would have allowed it to go into effect. The death penalty cases, the previous year, 6-3, 6-3. Almost certainly she would have been with the conservatives in the case, but still it would have been 5-4. Ineffective counsel, Roberts with the liberals. Maybe it would have been 5-4 in that case, so that might not have been affected. Here's an interesting one. Thomas and Alito, always with Trump. Whether Trump was a party or, as in many of these cases, even if Trump and the Trump administration were actually not parties to the case, they were not litigators, but they would submit an amicus brief, a friend of the court brief, taking a side on the issue. So ones in which they thought it was particularly important for them to speak up. Thomas and Alito were always with Trump, whether it was the Trump subpoena cases, the 2 Trump subpoena cases, whether it was the DACA repeal, every single immigration case, like the Trump administration against the immigrant. This case having to do with whether or not the president had the power to remove the director of the Consumer Finance Protection Bureau. They ruled in favor of Trump's power to do so. Federal executions, they voted in favor of the Trump administration. That's Barr. Renewing all the executions, and there's been many of executions taking place the last couple of months. And Bostic, of course, they were with the Trump administration against LGBTQ rights. The Obama administration was always in favor of LGBTQ rights. The Trump administration withdrew those briefs of the Obama administration, submitted their own against LGBTQ rights. The abortion cases, of course, Alito and Thomas always against abortion rights together with the Trump administration. Again, here's the voting. Here's the voting just flipped around. Now, what about Barrett? What about Barrett? Okay, the third nominee. 48 years of age. Just think of it. If the average age staying on the court is about 81, 82, she's going to be there 35, 36 years. She's appointed October 27th. She had been appointed to the appellate court 2017. She was a professor at Notre Dame. Previous to that, she clerked for Antonin Scalia, who she idolizes. Before that, Judge Lawrence Silberman, very socially and politically conservative. Of course, the senators were afraid this time around to ask her too much about her religion, as though that was irrelevant. But of course, it is terribly irrelevant if you have somebody that's going to become a judge and is giving speeches to lawyers and judges and conservative groups saying that all public officials, including judges, must remember that they are working for God and they are working for Christian truths. Well, I think that's a legitimate question, and she has shown herself to be extraordinarily conservative in that sense. Again, that doesn't mean that she's wrong on the law. It doesn't mean that she's foolish, right? It doesn't mean that a neutral interpretation of the law would take her somewhere else, but we know what is motivating her. Okay, here's what the ideological lineup was. Here's what it is now. When she was at the appellate court in criminal law, every single one of them, except for one, every single one of them, she was against the person who was accused, the person who was being prosecuted, the person who was being convicted, the person who was an inmate, every single time, except for one. We'll take a look at that. All right, in this case, the majority of the court said, hey, look, the defendant's sentence has to be reduced because Congress passed this First Step Act. She dissents, and she says the defendant's sentence should not be reduced because this wasn't his first sentence. That first sentence, which was illegal and was vacated, that still ought to be counted as a sentence, as a predicate in order to enhance his sentence, make his sentence even harsher. So even though it was an illegal sentence that was thrown out, it still ought to be counted. He ought not to get a more lenient sentence. Rutherford case, the majority says, look, if you have a defendant who is asking the court to reconsider its decision, in this case, reconsider a sentence, that extends the time that the defendant has to appeal to the higher court. In other words, you ask the court, the trial court, would you please reconsider my sentence? I think it's illegal or I think it's too harsh. Once there is such a motion, that stops the running of the time that I have to appeal. Well, the majority of the appellate court agreed with the defendant. Judge Barrett dissents. And she says that the motion didn't stop the clock, that these federal regulations, they supersede, they overruled the common law rule. And therefore, the deadline for appealing his sentence has expired. He shouldn't be allowed to appeal his sentence. She may be right, she may be wrong. Nevertheless, again, against the accused. In this case, the majority reverses the attempted murder. It was attempted murder, that was the conviction, and holding that it was a Brady violation. A Brady is a constitutional decision of the United States Supreme Court that if the prosecution has evidence that might help the defense, the prosecution is required to hand that over to the defense. They can't conceal evidence that might help the defense. Okay, in this case, you had the majority said there was a Brady violation because the prosecution did not tell the defense. It concealed from the defense the fact that the victim, the primary prosecution victim, had been hypnotized to refresh his recollection, had been hypnotized. They never told the defense that. So the majority of the court said, that's a Brady violation. You were required to tell the defense that. And they reversed the conviction. Judge Barrett dissents. And she says, oh yeah, the non-disclosure was a Brady violation, but it wasn't that bad. It was not an unreasonable application of Brady law. And therefore, the appellate court should not have thrown out the conviction. It should have affirmed the conviction. Schmidt versus Foster. This is an interesting one. Well, they're all interesting. The majority says, look, the trial judge violated the defendant's right to counsel. What did the trial judge do in this case? The trial judge called into his chambers the defendant and the defense counsel and he started questioning the defendant, but he would not let the defense counsel talk. He would not even let the defense counsel talk to his own client. He would not allow the defense counsel to object to questions or ask the judge any questions, ask questions of his own client, advise his own client, wouldn't let him participate at all. So the majority of the court says, hey, the defendant's right to counsel was certainly violated because you had the judge asking incriminating questions of the defendant and he wouldn't allow the defense counsel to talk to his client. Judge Barrett dissents. And she says, well, there wasn't the right to counsel at that hearing in the judge's chambers because it wasn't an adversarial hearing. Why wasn't it an adversarial hearing? Because the prosecution wasn't there. And since the prosecution wasn't there, it's not a quote unquote critical stage of the proceeding. And therefore, there's no right to counsel at such a hearing. Okay. Yeah, I mean, so you know where her mind is. She's very, very pro-prosecution in criminal cases. Prisoner cases. Okay, prisoners don't fare too well with Amy Coney Barrett either. In this case, the majority remands, they send the case back. 1983 action. 1983 action is when you say my constitutional rights were violated. The inmates brought an action saying my constitutional rights were violated because the guards used excessive force. How'd they use excessive force? They used excessive force, right? They used excessive force in this case because there was apparently a fight that broke out among the inmates. After the fight had ended and the inmates were subdued, the guards start firing shotguns into the room. And the bullets, the shots ricocheted and they injured a couple of inmates who weren't even involved in the fight. So those inmates brought this action that their constitutional rights were violated for excessive force. There was also something about the fact that the correction guards seemed to have lied about it. All right. Judge Barrett dissents. And she says, look, the guards may have acted with deliberate indifference, but that's not enough. Because deliberate indifference isn't enough. You have to prove that they actually acted with malice. They intended to hurt the inmates. Okay. Gun rights. Here's the one time where Amy Coney Barrett actually voted in favor of an accused, someone being prosecuted, somebody having been convicted, or an inmate. In this case, the majority says, look, federal and state laws that say that a convicted felon may not possess a firearm, those laws do not violate the Second Amendment right to bear arms. And they said, especially in a case like this, where the felonies were really serious and showed that these felons could not be trusted to possess firearms. The one time she sticks up for somebody who's been convicted, somebody on the opposite side of the law, she dissents and she says, at the founding era, the legislatures only stripped felons of the right to bear arms if they were actually dangerous, if it could be proven beyond a reasonable doubt that they were dangerous. But the founding era legislatures did not disarm all the nonviolent felons. Okay. She may be right. She may be wrong. She wanted to throw out federal and state laws that prohibit felons from possessing firearms. The next time you hear her talking about, oh, we should be deferring to the other branches of government because of judicial restraint, just remember this case. Not when it comes to gun rights. Again, which is not to say that she's wrong, but is to say that when it's about something she thinks is important, not only is she suddenly going to favor the criminal felon, she's also going to vote to invalidate federal and state duly enacted laws. Immigration law. The majority holds that the Department of Homeland Security does not have the discretion under the Immigration and Naturalization Act. So the Department of Homeland Security doesn't have the discretion under the statute, the congressionally authorized statute. Does not have the unfettered discretion. They don't get to do anything they want, right? To redefine public charge. Now, a public charge would be somebody, a non-citizen, who's not allowed into this country, not allowed to immigrate into this country. So the majority says the Department of Homeland Security can't promulgate any regulation whatsoever to say that an inadmissible public charge is any non-citizen with the lack of an absolute sense of self-sufficiency. In other words, any non-citizen who's likely to receive any public assistance in any amount at any point in the future. They said that's totally contrary to the statute. That goes beyond the statute. Barrett dissents. And she argues that the statute gives the Department of Homeland Security relatively wide discretion to specify the degree of benefit usage that renders somebody a public charge. So here she wants to uphold the regulation. As I said the last time, dealing with the last case, when you hear about judicial restraint, and in this case, when you hear about, well, Congress ought to be passing the laws. Agencies ought not to be promulgating regulations. It should be left up to Congress. Here, she's the one, and she's in dissent, wanted to uphold the regulation. Why? Because the regulation restricted immigration. I might cynically say it was also a position favored by the Trump administration. I don't think that escaped her.
Vincent,
abortion rights.
Vincent.
Yes, go ahead.
I just wanted to point out to everybody that it is 7 o'clock, and we typically end our lectures at that time.
I was thinking 7:30. I'm really sorry.
That's okay.
I'm really sorry.
So if anybody does need to leave, we understand that that we have recorded this program, but if you want to continue, we can stay on a few more minutes.
I've only got one case after this I was going to talk about. I'm sorry, I was thinking 7:30. Well, I love talking to you guys so much. All right, the abortion rights case. Do I need to tell you where she's going to vote? You had a majority of the court saying that this Indiana law, which required an ultrasound procedure at least 18 hours prior to the abortion. In other words, somebody wants an abortion, they got to go to the abortion clinic, get an ultrasound. Then they got to go home. Then they got to come back to the abortion clinic. And, some of these people live quite a distance away from the abortion clinic. The majority said that's an undue burden on the right to choose. Okay, you know where she's going to be. She joined the dissent saying, we ought to all reconsider that decision because we don't think this is an undue burden. And in this other case where you had another Indiana law, and this other Indiana law saying that there were only certain reasons for which a woman could get an abortion pre-viability. So they were restricting even pre-viability abortions. The majority of the court said you can't do that. That's a violation of Planned Parenthood versus Casey. That's an undue burden. Pre-viability, a woman's right to choose is just about absolute. Barrett joins the dissent saying we ought to be reconsidering that decision. All right? So, anyway, one last thing. Let me ask you this about this. Here, think about how Ginsburg would have voted on these cases and how Barrett is likely to vote on these cases. Separation of church and state, LGBTQ rights, gun rights, Racial issues like affirmative action, abortion rights, we've already seen that. Voting rights, voting suppression, immigration, death penalty, rights of the accused, environment, worker rights, consumer rights, campaign finance, Obamacare, Trump, and we're going to have cases about criminal proceedings and civil litigation against Trump. All right, so I guess I will end it there. Sorry to go over, but damn, I always have so much fun talking to you. So thank you so much for your attention. It was great. And I will certainly hang around in case some of you have questions for me. So thank you very much.
There's a few questions. The new court will have 6 Catholics. What is likely to be the effect?
Well, it depends upon what kind of Catholics they are. Good ones or bad ones? No, it depends. Some of them unquestionably will think that there are people such as me who are bad Catholics, right? In fact, Amy Coney Barrett has spoken in the past about what kind of Catholics are real Catholics and which kind of Catholics are not. So she gave a talk about a 13th century theologian, Pelagius, who said he was Catholic, and he said, what's really important is that you do good deeds while you are alive, and that will save you. And it didn't matter so much what particular things you had to believe, as long as you were a good person. She condemned in a recent lecture, she condemned that theologian in absolutely no uncertain terms. Who else condemned Catholics like that? Antonin Scalia. So we know how they're going to vote. So when you hear people saying it's completely irrelevant, you shouldn't be asking her about your religion, wait a minute. When you have these tough cases before the Supreme Court, you look at all the cases, you look at all the statutes, all the wording, all the precedents, and you get this far. There's still a gap. How do you fill in that gap? You don't think somebody's strong religious beliefs, somebody's strong philosophical beliefs, somebody's beliefs about the meaning of a free society, their own personal views are not going to enter? Well, of course they do. It's ridiculous to think that they don't. Are her religious views? Do you think, as the kind of Catholic that she is, right, who has signed on to statements saying how adulterous and how blasphemous and how sinful being engaged in gay intimacy is, and that abortion is murder, you think she's ever going to vote in favor of abortion or in favor of gay rights? How could you do that? If you really think that's a mortal sin, you're going to go to hell if you engage in that. How are you going to vote in favor of that, right? So there's that. There's that kind of Catholic. There's other kinds of Catholics, like Sonia Sotomayor, right? And like William Brennan was, like Anthony Kennedy was, and they are more what I would call Sermon on the Mount Catholics. Sermon on the Mount Catholics. Hey, look, you ought to be really, really good to people who are vulnerable. You ought to love your neighbor as yourself. Take care of one another, right? I don't care if you're a sinner. I don't care if you have leprosy. I don't care this. Just be good to one another, right? You have those kinds of Catholics. It makes a difference. I'm sure it's the same way in most, if not all, other religions. That kind of divide between dogma, right, and good works. Right. So it depends. The fact that there's so many Catholics on the court, I think, is not what the question is. The question is what kind of Catholics they are. We know what kind of Catholic Thomas is. We know what kind of Catholic Amy Coney Barrett is. We know what kind of Catholic Scalia was, what kind of Catholic Alito is. Gorsuch was Catholic, and he became Episcopalian. He became Episcopalian. Maybe the Catholic Church was too liberal for him, but he became an Episcopalian. So, yeah. So, good question. Yeah.
Well, there's one more observation / question.
Absolutely.
So we'll do that one. The observation: during the oral arguments on the State Attorneys General challenge Affordable Care Act, Justice Alito in questions mused about how losing the individual mandate was akin to a three-legged stool now missing its third leg. How is this relevant to the constitutionality of the act?
Yeah.
It's a valid public policy question, but that's not the court's role. Right. Alito's remark sounds like judicial activism to me, legislating by the court, which conservatives supposedly oppose.
Yeah, supposedly, I think the key is supposedly. Okay, don't believe any of that stuff. You know, no, I mean, really, look, legal realists, and I'm talking about the greatest judges, whether we're talking about Cardozo or Holmes or Posner or Jackson, they all knew what judges do, and they were candid about it, which is, of course, why they could never be confirmed today. I've said that before. They understand what judges do. You get to a point, and your own personal values have to come into play. So, for example, if there's a gap, and you could legitimately, under the law, go this way, or you can legitimately go that way. What you think that free speech is super, 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 super important, and therefore all those protesters ought to be let off, right? That's the way you're going to vote. On the other hand, if you say, yeah, I like free speech, but I think sometimes protest goes way too far, you're going to vote the other way. And there isn't anything that is going to dictate your vote. Now, with regard to Alito specifically, do not underestimate the man. He's one of the smartest people on the court. I wouldn't say that about Gorsuch. I would definitely say that about Alito. I think the man is absolutely brilliant. Agree with him or not, he's absolutely brilliant. This was his point in the Obamacare case. When Obamacare was upheld, and it was upheld by a 5-4 vote. You know where the liberals were going, and you know where the conservatives were going. What was the 5th vote? Chief Justice Roberts. What was his basis for upholding Obamacare? That Congress had exercised its taxing power in imposing the individual mandate and the penalty for individuals who did not obtain insurance. He said it was their taxing power. So, under the tax legislation passed, pushed and then passed in the Trump administration, that tax was removed. The individual mandate and its penalty were removed. So what Alito is saying is that if that tax was the whole basis for upholding Obamacare, how can you say that there's anything left to keep Obamacare alive? That was the only thing that kept it alive. The other argument is that Congress did pass a law, and that law amended Obamacare to get rid of the individual mandate and the penalty. They certainly could have repealed Obamacare, and they did not repeal Obamacare. So that was not the intention of Congress. So the intention of Congress was pretty darn clearly to keep Obamacare. Are you going to defer to Congress or you're not going to defer to Congress? What is your reason now for not deferring to Congress, you conservatives on the court? Yeah, I mean, that's exactly what's going on. It does sound like Roberts and maybe even Amy Coney Barrett. But it seems like there were a couple of conservatives on the court who wanted to uphold Obamacare. And they were looking much more at congressional intent to keep Obamacare, right? Because Congress couldn't get the votes to throw it out, right? To keep Obamacare, as opposed to what they actually did by removing the individual mandate. I'm pretty darn sure Obamacare is going to be upheld. I mean, look, at this particular point, it's so darn popular, right? It's so popular, and I think, the justices listen to what's popular and not popular.
Okay, Vincent, I have one. I make this the last question. Is it possible for the law to be interpreted apolitically, or do Supreme Court cases necessarily have liberal or conservative implications?
Yeah. It's possible that the decisions could be made apolitically, but they would have to be made based upon something else. And the reason for that is, for example, again, let's talk about these protesters, right? That seized the Capitol the other day. What about these protesters? There was one of them, for example, the guy with the horns and the fur, right? We all seen that guy with the horns and the fur? Cenk Agnelli, I think his name was, like he had to be Italian. Yeah, Cenk Agnelli is So Jake's argument is that, look, I didn't do anything bad. The door was open. Yeah, it was broken open. And all I did was peacefully walk in. And apparently he's not one that did any damage at all. He just walked into an open door. What does the First Amendment say? No law abridging the freedom of speech. None. Zero. None. All right. So that's impossible because there's got to be some speech that can be prohibited, right? Okay. Assassinate the president, assassinate the, okay, we could prohibit that, right? So, but you got to be pretty strict with that. So what about this guy, Jake Agnelli? What are we going to do with him? Because he's going to say free speech. And they're going to say, yeah, but you were trespassing on the Capitol. They weren't trespassing. There were all kinds of people walking through. And I stayed in line. I didn't damage any property. Okay. What do? You get here. What do you do? What do you do with that? Now, suppose I'm somebody that absolutely hates what those protesters did. And I hate Trump. I hate everybody that likes Trump. What am I going to do? But I say, look, I want to be neutral. I want to be totally and completely neutral about it because I know how important free speech is to this country. How can I be completely neutral? Well, I can think about how important free speech is, even if it's the kind of expressive activity, which I certainly wouldn't engage in, which I think is crude as can be, which I think, really ought to be discouraged. But should we criminalize it? Again, especially for that guy who just walked into an open door and didn't damage anything. I think that's a pretty close case. Now, if you say, I hate Trump, so I hate this guy, yeah, then you know how you're going to vote. Or I support Trump, so I'm going to support this guy. Then you know how you're going to vote. But if you want to be neutral about it, I think it's a tough case. I think it's a tough case. So it's possible. But I think the real question is it possible to answer these questions without injecting your personal values and views? That's impossible because there's nowhere else to go. I'm not going to call up Liz and say, Liz, I have no idea how to vote. You want to tell me? No, I'm going to inject my own, although she probably have a better idea than me, but I'm going to inject my own philosophy and values into the case.
And with that, we're going to end. And I want to thank everyone for joining us here today and sticking with us past the hour. Thank you, Vincent, for being with us again today.
Just loved it. Just absolutely loved it. Thank you so much for inviting me. Thank you. Thank you.